Minor sex trafficking lawsuits in New York. Attorney Andrew M. Stengel. Being trafficked as a child is a profound trauma. It can take years, sometimes decades, to feel ready to seek justice. If you were sexually trafficked as a minor in New York, federal and state law give you powerful rights and extended time to use them. A minor sex trafficking lawsuit does not require you to prove force, fraud, or coercion. The commercial sexual exploitation of anyone under 18 is sex trafficking under federal law. Full stop. Thus, we explain what that legal standard means for your case, who can be held accountable, and how you can pursue justice on your own terms. What makes a minor sex trafficking lawsuit different under federal law? Federal law, specifically the Trafficking Victims Protection Reauthorization Act, TVPRA, draws a clear line between adult and minor survivors. Adult survivors must prove their trafficker used force, fraud, or coercion. Minor survivors face no such burden. The commercial sexual exploitation itself establishes liability. This distinction matters enormously in a minor sex trafficking lawsuit against institutional defendants. Hotels, online platforms, schools, group homes, and foster care agencies cannot argue they lacked knowledge of coercion when the victim was a child. The strict liability standard removes one of the most common defenses these defendants raise. Furthermore, institutions that knowingly benefited from sex trafficking face direct civil liability under the TVPRA. A hotel that ignored clear signs of trafficking, a platform that profited from exploitative content, or an agency that failed to protect a child, all can face accountability in New York civil court. New York Social Services Law 483-BB. What institutions are required to do? New York State Social Services Law, Section 483-BB, requires covered entities, including hotels, motels, and certain other businesses, to post human trafficking awareness notices and train employees to recognize and report signs of trafficking. This law creates a baseline duty of awareness that courts take seriously. When a hotel or business failed to comply with Section 483-BB, that failure becomes powerful evidence in a civil lawsuit. It shows the institution did not take the steps New York law required to identify and stop trafficking on its premises. In other words, non-compliance is not just a regulatory violation. It supports a finding of negligence or constructive knowledge in court. Additionally, Section 483-BB imposes reporting obligations on certain covered professionals and entities. A group home, foster care agency, or other supervised residential setting that ignored trafficking warning signs and failed to report them as required faces heightened exposure in civil litigation. New York courts can use that failure to establish what the institution knew or should have known. Who is held accountable in a New York trafficking lawsuit? Civil sex trafficking lawsuits reach far beyond the individual who committed the abuse. The TVPRA and New York State Social Services Law, Section 483-BB, allows survivors to sue anyone who knowingly benefited from a sex trafficking venture. This opens the door to institutional defendants with significant resources. Hotels and motels that rented rooms for trafficking purposes face liability, especially those that violated Section 483-BB by failing to train staff or post required notices. Online platforms that hosted or profited from trafficking-related content can also be sued. Schools, foster care agencies, and group homes that failed to protect minors in their care have faced civil lawsuits across the country, including in New York. An experienced attorney will evaluate every possible avenue for recovery. The goal is to identify all responsible parties and pursue the full compensation you deserve. Extended filing deadlines protect minor survivors in New York. Many survivors do not come forward for years after the trafficking occurred. Federal law accounts for this reality. Minor survivors may file a sex trafficking lawsuit within 10 years of turning 18, or within 10 years of discovering that the trafficking caused their injury, whichever is later. This extended deadline exists because trauma shapes memory, disclosure, and healing on its own timeline. New York courts recognize that survivors cannot always act immediately. Therefore, the law preserves your right to seek justice even if significant time has passed. In addition, New York allows trafficking survivors to file civil lawsuits using a pseudonym. Your name does not appear in public court records. This protection applies throughout the entire litigation, not just at the initial filing stage. We stand with survivors. Reach out when you are ready. You decide when the time is right. There is no pressure and no obligation. The law firm of Andrew M. Stengel, PC, represents survivors of minor sex trafficking throughout New York with the sensitivity and determination these cases demand. We understand that every survivor's path is different, and we work on your timeline. Our law firm works on a contingency fee basis. You pay nothing unless we recover for you. Contact us for a free, completely confidential consultation. Email info@stengellaw.com. For more information, please visit our website, stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.